Welcome everyone, and thank you for joining us today for our presentation on the ATO's guidance material on Division 7A and Section 100A. Now, I'll just introduce the speakers for today. So, my name's Alexis Kokonos. I'm a tax partner in our tax consulting division. I head up our national tax technical team and I lead our consultation with ATO and Treasury. I'm the chair of the CPA's Tax Technical Committee and a member of the ATO's National Tax Liaison Group. As a part of that, I've been consulting with the ATO on this draft guidance, which we're going to cover today for over 2 years. I'm joined today by Chanel Palmer and Leo Gusenfeider, who are senior managers in our National Tax Technical Team, who I'm sure a lot of you have already met before. So prior to joining Pitcher Partners, both Chanel and Leo had previously worked at the ATO. Chanel had been a part of the law interpretation team of the ATO and also worked with Treasury on Division 7A tax reforms. Leo had also worked in the Tax Council network of the ATO and also worked in the private wealth area of the ATO. Both Leo and Chanel have extensive experience on trusts and Division 7A and also have been involved in the consultation process on these documents. So I'll move into our presentation. So what are we talking about today? So on the 23rd of February 2022, the ATO released some guidance material on Section 100A and Division 7A. Now, we'll be going through what those things mean today in quite a bit of detail. But at a high level, these documents are dealing with the treatment of trust distributions for income tax purposes. There was 4 documents that the ATO released. They released a draft ruling on Section 100A, a PCG on the operation of Section 100A, a draft determination on unpaid entitlements to corporate beneficiaries, and a taxpayer alert on distributions to adult beneficiaries. What's really important about these documents is the ATO has significantly changed their view and long-standing practice on the treatment of trust distributions. As you'll see from today's session, the application of the new ATO view is very, very complex. And so we'll try to explain these concepts to you in a simple manner, but no doubt we won't be able to go through these in any great detail today. It is safe to say, however, that going forward, managing trust distributions between group family entities or group entities and family members will need to be managed very, very carefully every single year. It's also safe to say that this area will be something that is highly scrutinised by the ATO going forward and something that should be looked at by groups very closely to ensure that you reduce your risk in this area. So the agenda for today is on the slide, and I'll just briefly touch on what we're covering. First, we're going to talk about Section 100A and how that provision can change the tax treatment of trust distributions and effectively result in a 47% tax rate on trust distributions. And in some cases, it can result in more than 47% when distributions go to corporate entities. So we'll talk about Section 100A. It was a provision introduced in 1979, and the ATO have only released or provided a view on how these provisions apply recently. So we will discuss the provision and the ATO's view on the exception for ordinary commercial and family dealings. And we'll talk about how narrow the ATO have taken a view in respect to that exception and how broad the provision may apply under the ATO's view. We'll look at the tax treatment of distributions to corporate beneficiaries, and in particular also how unpaid entitlements will be treated under the new ATO view. We'll consider the application date of the ATO's new views and what it may mean for existing arrangements and new arrangements. We're going to discuss some implications for your year-end distributions for this 30 June 2022 and future years. And finally, we're going to discuss some options around existing instructions and dealing with legacy arrangements. So I'll introduce the first topic and provide a little bit of background to Section 100A. So Section 100A is a provision that's designed to target trust distributions where there's a tax benefit received from the distribution. For example, someone pays less tax because you've distributed to that person. And within the arrangement for 100A to apply, generally there has to be someone else or another entity that receives a benefit in relation to that distribution arrangement. Now, Leo is going to go through those provisions and those conditions in a lot more detail, but that's effectively the gist of the provision. So if we took a simple example, which could include a trust distributing to an income, distributing its income to a person with losses, they may not pay tax because they've got losses, so there could be a tax benefit. And that person may agree to give back the money to another person who would have paid higher tax, and they may take a small fee for doing that. So that's the type of arrangement 100A was designed to target, and what the provisions were introduced to deal with back in 1979. Where 100A applies, it effectively switches off the distribution for tax purposes. Essentially means that the trustee is required to pay tax on the distribution at a rate of 47%. Now, the interesting part of this provision is the ATO has an unlimited amendment period, unlike any other provision, such that the ATO can effectively go back and review tax returns all the way back to 1979 and make amendments all the way back to that date as well. So pretty much all trusts would be open for this provision all the way back to that date. From my basic explanation of how the provisions could apply, you can see how the provision could be very broad if the ATO took certain interpretations. Now, no doubt, when the provision was introduced, that risk did exist and was identified back then. There was a lot of press release articles and there was a lot of discussion in Parliament at the time. I'm just going to read a quick quote that was taken from Hansard when the provisions were introduced. And it went like this. It said, without taking any time to discuss it, the second matter, which I hope the Treasurer would have another look at some stage, is proposed new section 100A. I hope in particular he would look at the definition of reimbursement agreement and then the definition of agreement itself. I might say there's a strange form of drafting of a definition of reimbursement agreement and subsequent to that, a definition of agreement, but I'll leave the peculiarity of the drafting to one side and say that merely that the provisions which are contained in this bill, because of their very broad definitions that they're given, are such that they may well have to be re-examined at a later stage. So they acknowledged how broad this provision could be read and that at some time one would need to probably re-examine the breadth of this and whether it was really targeting what it was intended to target. And if you do look through those documents, these provisions were targeting in 1979, a lot of those bottom of the harbour transactions dealing with loss trafficking. Unfortunately, however, when we now have the ATO looking to apply that provision to what we would say is family distributions or family group distributions, and unfortunately, ATO is taking a very broad view on when we have a tax benefit and when these provisions can apply, and such that we believe that the ATO are going further and applying these on a much broader extent than the provisions were originally intended. Now I'll hand over now to Leo, who will go through the technical operation of the provisions and talk about that further.
Right. Thanks, Alexis, and good afternoon to everyone in attendance today. So I'll be taking you through the Section 100A portion of our presentation, and I'll start with a very brief summary about the main elements of Section 100A before going through some examples from the ATO's recent guidance. And while we could easily spend many hours talking about the details of the section, we'll just provide here the 4 basic requirements for the section to apply as outlined in the Commissioner's recent tax ruling on the section. So the first of the requirements is there must be a nexus or a connection between a present entitlement to trust income and a reimbursement agreement. Now, what is a reimbursement agreement? It's an arrangement, agreement, or understanding that satisfies the other 3 basic requirements on that slide, being that it provides for a benefit or a payment to some entity other than the presently entitled beneficiary. It involves a purpose of reducing someone's income tax liability for that year, and it was not one entered into in the course of ordinary family or commercial dealing. And to state what Alexis outlined, Section 100A is designed to prevent the beneficiary who is taxed on the trust's income in situations where they're not actually enjoying the benefit of that income, and where there's tax-driven circumstances around that aren't considered ordinary dealings, and apply a penalty rate of tax or the top rate of tax on that trust income in those arrangements. So the ATO's draft tax ruling, TR 2022 D1, sets out the ATO's legal interpretation of all the key elements of Section 100A. Now, this is quite a dense and highly technical document, often difficult to read, and we don't propose to go through the analysis in any great detail. But none of the views in the ruling we think are new or particularly radical, I'd say. It's, like I said, an old provision going back to 1979. But I guess what's most relevant is how the ATO, what they're saying about how they're going to look to apply this from now on. And that's where the examples can be illustrative. The ruling itself contains examples of 9 arrangements, 6 of which stated to be those that would be considered ordinary dealings and not subject to 100A. Now, the key points that come out of the ruling are those that relate to the ordinary family or commercial dealing exception. And the ATO states that this exception is likely not to be satisfied where the arrangement has tax-driven features. Now, the other key point is that, so it's the first comprehensive tax ruling that considers the section, and it provides the view as applying both retrospectively and prospectively. So it's not from the date of finalisation, it's all the way, it's the ATO's view of how the provision works all along. So we also have a draft PCG, or practical compliance guideline, that accompany the tax ruling, which contains a lot more examples and also seeks to place taxpayers into a particular risk zone based on the features of their arrangements. So we'll go through what these are. Firstly, there's the wide zone, which deals with older present entitlements, being those made before 1 July 2014. Well, the ATO are saying they're ruling out going back before 2014 and earlier years, unless the arrangements are considered higher risk and are still ongoing, or tax returns for the trusts and the beneficiaries for those years weren't lodged by 1 July 2017, or the taxpayer is already under review or audit in respect of those years. So while we've heard some commentary from the ATO representatives recently making statements that it's only going to be in very rare and exceptional circumstances that the ATO is going to go back that far, would like to think that's true, but unfortunately, reading the PCG doesn't seem as restrictive as what they're been saying publicly. And we have many taxpayers have outstanding UPEs from well before 2014, and these could be considered ongoing arrangements and theoretically not in the white zone. Now, the green zone contains 3 scenarios that are considered a low risk of compliance activity. The red zone contains 6 scenarios considered high risk of compliance activity. And this blue zone is a bit of a catch-all for anything that doesn't fit into any of the other zones. And the ATO said that they may undertake some compliance activity to better understand the arrangement. And the PCG also lists a few features which may place a taxpayer into the blue zone. Now, to reiterate, this does have an element of retrospectivity as it applies to distributions made before and after when these documents were published. But the ATO in this PCG does state that taxpayers can rely on an ATO fact sheet, which was web guidance published around 2014, where that is more favourable to the taxpayer, and we'll comment on what that is later in the presentation. So that's a very brief summary of the 2 big products, the ruling and the practical compliance guideline released by the ATO on Section 100A. And there are a lot of examples contained in the products, too numerous to go through today. But what we want to extract out of that is what we perceive to be the key themes that come out of the guidance and distill the main messages. So, and these are the themes we think are critical on this slide. They're distributions involving family members, trustees retaining the funds that the beneficiaries were made presently entitled to, whether as an unpaid present entitlement or as a loan back, where the UPE is converted to a loan back to the trust. And those can involve both discretionary and unit or fixed trusts. There's also distribution to lost entities and certain arrangements considered artificial or contrived, including those that exploit tax to accounting differences and those that involve a circular flow of funds. And we'll go through these in turns, starting with probably the most important one, distributions or arrangements between family members. So this is the main message we think that's coming out of the ATO guidance. Essentially, they've come out, put everyone on notice and made it very clear that they will go after arrangements involving family members and seek to apply Section 100A in certain cases. There may have been a view or school of thought that Section 100A generally applied to far more egregious or highly contrived cases known as trust stripping arrangements involving, for example, the introduction of a tax exempt or a loss beneficiary to ensure no tax is ever paid on trust income. However, the ATO are putting out a view with these rulings and other guidance products that arrangements even between close family members that seek to benefit from each other's marginal tax rates in what otherwise may be considered ordinary tax planning are now going to be potentially subject to, well, 100A or always were, but the ATO is now making it clear what their view is. So we have here what we think is the key quote from the ruling, which states that having an objective to reduce collective income tax liabilities of a group or family unit in order to maximize the post-tax group or family wealth will not be considered an ordinary family dealing. Therefore, distributing to a lower taxed family member but sending those underlying funds to some other family member is something the ATO believes Section 100A applies to. And the fact that it's family members dealing with each other is not enough to satisfy the ordinary family dealing exception. So let's go through some of the examples in the ATO guidance involving family arrangements. The first one involves a testamentary trust, which distributes income to the grandchild of the deceased. And the first thing to note here is that Section 108 simply cannot apply to the years when the child was a minor. That's just basic interpretation of the provision, but it can for the years after that beneficiary or grandchild turns 18, so between 18 and 25 in this case. The ATO state, though, as this was done pursuant to a will, Section 108 generally won't apply to this situation involving the trustee reinvesting and retaining the funds for 7 years. And that should be considered an ordinary family dealing. The next example we have here seems to be the only kind of example involving the utilization of marginal tax rates between family members that the ATO sort of endorses or states that it generally will not apply Section 108 to. And that involves spouses who have mixed finances and who hold assets jointly. The ATO state that generally they won't seek to apply 108 to arrangements involving spouses and seem to be saying that distributing income to a non-working or lower income spouse, let's say to make them up to a taxable income of 180,000, might be okay, where the funds are shared, where spouses generally share all the funds, all have mixed assets, and they might share this distribution and they might hold other investments jointly as well. Now, the ATO seem to be imposing, what many are saying is a value judgments and ideals about what an ordinary family is and how it's structured and how they ordinarily deal with each other, and have received some criticism as being too biased towards a Western nuclear family structure. They say that once you move outside arrangements involving spouses and you involve children and elderly parents, then arrangements that seem to involve some sort of tax benefit are at higher risk of Section 100A applying. These could involve gifts between a parent and a child, non-commercial or interest-free loans between family members or entities, or gifts back to the trustee. Now, ultimately, the ATO kind of hedges their bets when talking through these kinds of arrangements. But essentially, what comes out of the ruling and practical compliance guideline is that the ATO say gifts and loans are okay where it is a higher tax beneficiary gifting or loaning the amounts to a lower tax beneficiary. Presumably, tax can't have been a purpose of the arrangement, so therefore it must be an ordinary deal. For example, a parent on high income gifting some money to their child to help put together a deposit on a family home. However, in the opposite case, where a low tax beneficiary gifts or lends to a family member with a higher tax rate, then presumably this has to be tax driven and therefore not an ordinary family dealing. So even if it's the exact same fact of a parent gifting to a child for a home deposit, if the parent was, let's say, retired and on a low income or lower income than their child, then Section 108 could apply just because of the marginal tax rates of the people involved. So that's probably, in essence, what the key theme that comes out of these products are regarding family dealings. Distributions to lower tax beneficiaries will come under scrutiny, and the ATO will want to know that that lower tax beneficiary has actually enjoyed the benefit of their entitlement. The ATO rulings don't seem to factor in other things, however, such as wealth. For example, someone may have substantial wealth, but not much income for a particular year. Nevertheless, because of the assets they hold, it might make sense for them to be making gifts to family members, despite not actually having much income that year. So the ATO doesn't factor in these other considerations. They seem to be honing in and just focusing on what are the marginal tax rates of the people involved. One last thing, or one last point to note on this, the ATO also highlight that lower tax beneficiaries it's not just about marginal tax rates. They could include beneficiaries which are taxed concessionally on certain kinds of income, particularly non-residents who pay lower tax rates on things like interest income, which generally tax 10% on a withholding basis, or even foreign sourced income that goes to a non-resident, which is tax-free. So the ATO has also put out third product, which this is a final product, it's not in draft, it's a taxpayer alert specifically covering distributions to an adult child aged 18 years or over. Out of all the examples that were contained in the ruling and the PCG, this is the one they have gone over and above and put out a separate alert. Essentially, they are thinking to throw the book at these kinds of arrangements, which many previously thought were things that are ordinary family or commercial dealings. Now, in the taxpayer alert, the ATO do not accept that a child should be using distributions to pay for things probably considered parental expenses. So this is a concept that the ATO have created in this alert. And again, they appear to be imposing value judgments and potentially straying into areas of policy making by suggesting a child shouldn't be repaying their parents for raising them once they became an adult. But that it's okay for a child to pay for their own uni fees, but not their own high school fees. Or to pay their parents reasonable board if they're still living at home once they become an adult, but presumably not okay to pay them some sort of rent or board while they're still in high school. Ultimately, this again highlights that the ATO don't like family trusts using up the lower tax brackets of lower income adult children and putting everyone on notice, so nobody can say they weren't warned about these arrangements. Now, in the alert, the ATO say they may apply Section 100A, as well as some other provisions, potentially applying Section 97, which is a direct assessing provision in the trust rules to assess the parents directly if they've benefited from the income, or also potentially argue the resolution was a sham. And the ATO also, the alert also includes comments that have some tax practitioners a bit concerned, as it highlights the potential application of the promoted penalties rules and referral to the tax practitioners board in respect of these kinds of arrangements. So moving on from family arrangements, the other key theme involves the trustee retaining the funds underlying the distribution or having them converted into a loan back to the trustee. So the practical compliance guideline contains a green zone setting out in what circumstances this will be permitted. So the first element of this is a retention of funds condition. It considers who the beneficiary must be in order to get into the green zone. And the ATO only seem to accept that trustees can retain funds where distributions were made to the main controlling mind of the trust or his or her spouse, so to an individual, or to an individual that manages the trust business or employed in the management of the trust business. You can't get into the green zone if distributing to other family members, such as siblings, children, parents of the controlling entities, and the funds are retained in the trust. And you can use a corporate beneficiary, but only where that corporate beneficiary is controlled by the controller of the trust. And with a corporate beneficiary, you must have a UPE or loan back on Section 109N complying terms, which you probably would do anyway to make sure you don't have a deemed dividend under Division 7A. Now, the main gap in this green zone is that it does not cover distributions made to other trusts. In private groups, this is a common occurrence, and while Section 100A does not apply where amounts flow through the second trust, it can apply where the second trust applies losses against its distribution from the first trust. And we'll be looking to make submissions to the ATO to extend the green zone to cover trust-to-trust distributions within a family group in the final PCG, because we think they're common enough scenarios that we should have more comfort on. The other aspect of this green zone and to fit into it is you must satisfy a use of funds condition. So it is pretty broad in what the ATO says are acceptable uses of funds where the trustee retains them. They can be used in the working capital of the trust business to purchase an investment asset of the trust, or even loaning out to related parties, so long as that's done on a Section 109N loan term. So there is a bit of flexibility here, although it's a bit unusual. There's a requirement of a Section 109N loan out of the trust where there might be no company involved in the arrangement. And to us, it seems a bit of an artificial restriction on making loans to related entities, as we think other kinds of terms should be considered ordinary commercial dealings. But the key thing to note is the PCG expressly states things like rent-free uses of property would fail the use of funds condition. So where UPEs are used to fund, say, the purchase of a holiday home, the ATO expects a commercial rental charge to be paid to the trust where family members and their associates who control the trust use that property or that holiday home. So that covers retention of funds and when the ATO allows for that. Now, moving on to some of the other themes on Section 100A, we thought we'd set out the 6 red zones identified in the PCG. Now, some of these may be seen as common arrangements, particularly scenario 1 involving gifts and loans, which we've already touched on. So without going through all of these in great detail, as we've already touched on a few, we want to briefly highlight a couple of other scenarios. So the 3rd red zone highlights that Section 100A can apply even to unit trusts, particularly where unit holders reinvest or loan back their distributions to the trust. So the ATO seems to be concerned with arrangements where entitlements are converted into units, essentially a debt for equity swap. In particular, where the amount owed and set off is greater than the value of the units received in return by the unit holder. Essentially, it's seen as the beneficiary giving some value away that may benefit the trust and other unit holders. And there's an example in the PCG involving a hybrid trust with different classes of units. This red zone does not appear to be strictly limited to hybrid trusts only. But the ATO also state that where there is a unilateral right with a trustee who exercises that right against a unit holder to convert their distribution for more units, and this will be in the red zone even where the reinvestment is done for market value. So the ATO don't distinguish between very closely controlled unit trusts and those that are widely held investment vehicles. And you would hope in the latter case that these would be viewed as ordinary commercial dealings. But at the moment we have these arrangements that appear to be in a red zone. So red zone scenario 4 involves the exploitation of tax to accounting differences. But the ATO provide a detailed example in the PCG and ruling illustrating this involving a share buyback, which we don't have time to get through today. But in essence, what this covers are situations where, for example, you might have a trust with, say, $100 of taxable income and $10 of trust income to distribute, with the other $90 that came in during the year representing capital. And you may choose to send the $10 to, let's say, a company or corporate beneficiary, which would result in that corporate beneficiary paying tax on the full $100 of taxable income at corporate rates, but then send the $90 of capital to an individual purportedly tax-free. Now, the ATO seem to focus on situations where that tax to accounting difference is contrived, such as where the trustee exercises a power or the trustees vary to create that difference, but maybe not so much where that difference arises organically or through normal accounting processes. So there are a few other scenarios there, and we'll talk to some of these on the next few slides. So the 5th red zone scenario involves the use of lost beneficiaries where the funds or economic benefit associated with that net income are not enjoyed by that beneficiary. Now, this is what Alexis mentioned, what 100A was ostensibly introduced to target specifically. But this is now just one of many red zone scenarios we have in this guidance. So the example in the PCG involves a trust introducing an individual with significant tax losses who is outside the family. They're introduced as a beneficiary of the trust, and they receive a distribution and don't pay any tax because of all their losses, but they don't get the benefit of the money. The money stays with the trust. Now, this example is clearly a late 100A arrangement. We don't really think it's necessary to have this in the guidance. It's pretty obvious as something that should be caught. But as I mentioned earlier, we'll be looking to make submissions to the ATO to provide for green zone scenarios where distributions are made to lost trusts and companies within family trust elected groups, as we do not think Section 100A should apply to these. And at present, it's somewhat ambiguous as to what it means for an economic benefit associated with the trust net income being utilised by some other entity. For example, if the lost trust uses it to pay down debt to another group entity, does that mean the creditor received the benefit or the debtor trust received the benefit? And it's a bit unclear at this stage, unfortunately. So we're hoping to get some more guidance around distributions to lost entities within groups and getting those into a green zone in appropriate circumstances. Now, when talking about the theme of circular flows of funds, we set out here a basic example of a dividend and set-off arrangement. What we have here is in year one, we've got a distribution of $1 million made by Trust B to Zedco. And Zedco is owned by another trust, Trust A. Now, some money sent to Zedco to pay its tax bill on that distribution, but 700,000 is lent back on a Division 7A loan. Now, in year 2, how do we manage that Division 7A arrangement? Well, commonly we might see the company pay a franked dividend, let's say 200,000, if that's what its minimum yearly repayment was. And that distribution goes to Trust A, which might choose to distribute that to Trust B, which uses the funds to repay part of the loan. But Trust B distributes that income, and which remains unpaid at this stage, to an individual who pays tax on marginal rates. So we might commonly deal with UPEs and loans involving companies this way. And we deal with them by paying top-up tax in subsequent years. Now, the ATO don't have this example in a low risk or even high risk scenario, but they do make a comment that where a UPE or one that's converted to a loan is repaid by the trust from funds sourced from the beneficiary directly or indirectly, then this will no longer be considered a green zone retention of funds scenario, and you'll end up in the blue zone. So because we commonly deal with Division 7A loans this way, with appropriate top-up tax being paid, we're hoping to get further clarity around this from the ATO to outline what exactly they're concerned about and put specific scenarios in red zones if appropriate to do so, as we think this of itself shouldn't be something ATO case officers see and start pursuing potential 100A cases on. We think the ATO are concerned where these sort of arrangements involve the subsequent dividend, let's say in year 2, flowing back to the same company or even another company. But where it goes out to an individual and individual rates of tax are paid, then we believe that there's no mischief and that this should expressly be in the green zone. But at the moment, that, even if you pay 47% tax in year 2, seems to put you in a blue zone. So what the ATO do highlight as a clear red zone arrangement is what is known as, or what's described as a washing machine arrangement, where basically the trust keeps the funds, avoids a Division 7A deemed dividend as the UPE is satisfied every year and goes round and round. So basically in year 1, we got a distribution down to a wholly owned subsidiary, which in year 2 pays that back as a franked dividend up to the trust, which then distributes that franked dividend income back down to the company, and that's repeated endlessly. So this was in an old fact sheet. It's nothing new. It's everyone sort of should be aware that that's something ATO will seek to apply 100A to. But you may be aware of a recent federal court decision in a case called Guardian AIT. Now the facts look slightly similar. We have to start with distributions down to a wholly owned corporate beneficiary and their distributions of rental income. Now the key difference is that it went back up to the trust, but out to an individual who happened to be a non-resident. It didn't go back down to the same corporate and round again. But it's important to note that no withholding tax or top-up tax was paid, as and tax for non-residents is capped at the 30% corporate rate where it comes through a company. Now, if the distributions were made in year 1 directly to Mr. Springer of rental income, they would have been taxed at 45%. So while there are differences between the two scenarios, it's not those differences that are important. It's the facts and evidence that is the reason why the taxpayer won in this case, noting that it is on appeal and it may be overturned yet. Ultimately, the court held that there was no identified plan involving these steps 1, 2, and 3. There was simply an intention to distribute income to a corporate beneficiary for that corporate beneficiary to invest and accumulate wealth. It was only later decided that Mr. Springer needed funds, and then he took out a dividend out of the company at the time and floated through the trust to himself. There was simply no step 2. There was just another step 1 in a new arrangement. The key being that the arrangement to benefit someone else must exist before the present entitlement is conferred. So where there is a break in this chain and you have 2 unrelated events, one being the present entitlement and the other being the payment or benefit to someone else, and that is essential to defending any position against the ATO. Now, because they're going to come along in hindsight and identify these things that look like 100A arrangements. They're going to see this happen and then this happened. But ultimately, what will come down to based on this decision is whether there's any evidence suggesting ahead of time that there was a planned sequence of events. If not, the ATO may struggle to prove their case, as they may only be left with assertions or some sort of implied, informal understanding that certain things would happen, but no direct evidence of that plan to do that. So to conclude on 100A, we'll touch on the ATO's fact sheet. To reiterate, there is a potential retrospective application of the ruling in PCG with the only protection provided is by this fact sheet. The ATO says where it's more favourable to taxpayers, you can rely on that. Now, unfortunately, the fact sheet can be somewhat vague as it's not anywhere near as detailed as the guidance that has just come out. However, there are some key points to get out of the fact sheet. They are that, one, it endorses bona fide loans between family members where there is a genuine intention to repay the loans and can include interest-free loans in some cases. It also contains examples of a trust with many UPs outstanding, lending out amounts to various individuals on what is described as, quote, commercial terms. It doesn't state what those commercial terms are, and that provides a much greater degree of flexibility than in the PCG green zone going forward, which only lets things be lent out on section 109N terms, so a 7-year interest and principal loan. Now, the fact sheet also talks about interactions with Division 7A and states the ATO will not apply compliance resources to review older UPEs where certain conditions are met, such as where they're put on complying terms or complying subtrust arrangements and where they're used to fund a working capital of a trust, but not, for example, where UPEs have been used to fund the purchase of an asset such as a holiday home that the family members stay in. So for those type of arrangements, it may be necessary to consider whether these need to be wound up or reviewed. And on that theme, I'm going to hand back to Alexis to go through some of the key takeaways for section 100A.
Thanks very much, Leo. Leo's given quite a comprehensive outline of section 100A. And I'm just going to quickly touch on what I see as the key takeaways from that session. Obviously, we couldn't go through it in a lot of detail because it is very complex and there is a lot of detail in the materials. But the key takeaway is that the provisions, the ATO's interpretation of section 100A is very broad and is likely ATO will apply this to a lot of arrangements that otherwise many advisors and taxpayers wouldn't have thought section 100A could apply to. It is difficult to provide absolute guidance on what the ATO will accept because the ATO have been very ambiguous as to what will attract section 100A. And as Leo pointed out, the examples sort of sit on the fence on many cases, so they don't really provide appropriate guidance on when 100A should apply. Further guidance is likely to develop between now and 30 June or shortly thereafter because there are a number of court cases going through the courts on section 100A. There's the Guardian case, which is on appeal, and there's another case that is going through on section 100A. And at the end of the day, the decisions could say anything about section 100A, and we may have to live with what the courts decide on the provision. As Leo pointed out, it is pretty critical, though, that when you are doing distributions, that there is no real plan in respect of what happens with the distributions, such that when you are doing your distributions for 30 June, they are put in place and that they don't consider design plans or schemes involving where the money will be paid to in order to have that nexus that Leo was referring to. So it is important to consider that there's no actual plan in place at the time of distributions. It's also important to consider whether distributions are going to be paid to beneficiaries for their own benefit, ensure that all beneficiaries are actually aware of their distributions and their entitlement to receive amounts, so that the ATO can't infer that they're contrived distributions. To the extent that after year-end beneficiaries wish to deal with their distributions other than receive cash, those wishes should be properly considered and documented. So in those cases, you would need to really consider what you're doing with the distributions. If a trust is looking to retain the funds and leave a distribution unpaid, so unpaid entitlements going forward, it's really critical that you do consider whether you meet the retention of funds scenarios and exceptions that the ATO has provided as being low risk. You should be considering your historic distributions, generally to 2014, and consider whether any of those distributions could be categorised by the ATO as being high risk. Finally, it's important to keep track of further guidance and judicial decisions in this space, as it may have an impact. The court cases could come out with an interpretation that's even harsher than what the ATO has come out with, or may come out with interpretation that is more lenient. So it is important for groups that have trusts to monitor this situation. So that ends the Section 100A section. I'm now going to hand over to Chanel, who's going to take us through the ATO's change interpretation on Division 7A.
Thanks, Alexis, and thanks everyone for joining us today. So that brings us to the final product in the ATO suite of guidance that they released, the fourth of them. It's Tax Determination 2022 Draft 1. In this document, the ATOs outlined their view that a private company with unpaid entitlements for a trust will provide financial accommodation to anyone that the company allows to have access to those funds to which they're entitled. It replaces their existing views in their previous products, so Tax Ruling 2010/3 and PSLA 2010/4 for any UPAs that arise after the 1st of July this year. And that's something I do want to pause and stress before we go on. The determination doesn't apply in respect of entitlements that arise this financial year. There's a few things that you might want to consider in terms of preparing yourself or taking advantage of what the ATO currently has available, which we'll step through in a little bit more detail later. But this is still a draft determination and this year's entitlements aren't affected. Having got that out of the way, in practice, what the determination does is essentially push all UPEs into Div 7A, except in very limited circumstances, with the only out then being a Div 7A complying loan agreement. Now, previously, the ATO did allow a company and trust to place the amount on 7 or 10-year interest-only loan terms. These arrangements won't be available going forward. As we'll soon get to, the main consequence is really going to be, from your perspective, the question of timing. So when do these UPEs have to be paid out or put on complying loan terms? That's what we see as the major change in this determination to come out in respect of the ATO's views. Again, obviously this is only in draft form, so we'll continue to liaise with the ATO and campaign for consistency and simplicity, but we don't really expect the ATO to move very far from the essence of their position. So we'll start with the basic case. The determination sets out the Commissioner's view that where a private company is made entitled to an amount of income from the trust and that amount's not paid to the company, then the company provides financial accommodation to the trustee by failing to call on that entitlement. That's what they refer to as circumstance 1 in the ruling. You'll notice that this is broadly similar to what they had in their previous rulings. Financial accommodation occurs when the company has knowledge of an amount that it can demand, being the UPE, and doesn't call for the payment of that amount. So they're allowing someone else, in this case, the AB Family Trust, to have use of those funds. This one requires the amount to be placed on the complying loan terms under Div 7A between Exco and the Family Trust in this scenario. Again, this isn't any different to what we currently have. That brings us to what the ATO calls circumstance 2. And what the ATO says is that if, on the other hand, the trustee satisfies the entitlement by placing it on a separate trust, so a sub-trust, then there's no unpaid present entitlement between the main trust and the company. So in this case, there's no present entitlement between AB Family Trust and Exco because it's been put aside for Exco's sole benefit. In these very limited circumstances, the ATO will accept that the company will not have provided any sort of financial accommodation because the amount remains available for the use and benefit of the company entirely. So provided the funds aren't used by anyone else, then there won't be any Div 7A loan between Exco and the Family Trust or the sub-trust. If, however, those sub-trust funds are actually used by an associate, then the ATO says that the company will have provided financial accommodation by allowing that associate to use those funds. The most common scenario we see here is where the Family Trust makes a distribution to the company. So AB Family Trust makes a distribution to Exco, puts that amount on sub-trust, so puts it in a separate bank account, but the Family Trust continues to use those funds for its own purposes. So that could be towards working capital in its business, for example. If this happens, the ATO says that there's financial accommodation provided by the company directly to the associate, so a loan from Exco to the Family Trust. The amount then therefore needs to be put on complying loan terms between those two entities. Importantly, the ATO doesn't accept that a commercial return, so from the Family Trust to Exco, is sufficient to negate the financial accommodation that's provided by the company in allowing the trust to use those funds. So even if the family trust were to pay interest on the use of those funds, there's still going to be a DIV 7A loan, irrespective of whether that interest rate is actually higher than the DIV 7A rate. Consideration could be given to discharging the entitlement, just directly loaning back from the company to the trust to avoid the complications that arise from the subtrust arrangement and any other administrative details that need to be taken care of, which does make it a little bit simpler. But really the difference between ultimately the UPA being a loan or not turns on the use of those funds, either by the company allowing the main trust to use the funds or by allowing an associate, which could still be the main trust, or another entity to use the amount that's placed on subtrust. If either of those things happen, a loan arises, which ultimately means almost all UPEs will be subject to DIV 7A, except in those really limited scenarios where they're appropriately placed on subtrust and no other person benefits. As I said before, other than the removal of the PSLA subtrust, so the 7 or 10-year interest-only loans, this is very similar to what we had already. The difference you'll find is really in the timing. The timing of the financial accommodation, so in other words, the timing of the loan, will be the point at which the private company has knowledge of an amount that it can demand immediate payment of from the trustee and doesn't demand that payment. You'd remember in the ATO's previous rulings, there was essentially a year's deferral where the Commissioner accepted the loan would arise in the year following the UPA. And this really made sense as it wasn't often until the next year that the financials were prepared and the quantum of the entitlement, or indeed whether there even was an entitlement, was determined. So it wasn't until that point at which the beneficiary would know there was something that they could demand. Disappointingly, the ATO hasn't adopted a consistent approach to timing similar to those other rulings. Instead, what we have is the determination says that where there's a distribution by the trust to the company for a fixed or specified amount, so they refer to it as a sum certain, the company will be taken to have an immediate knowledge of the entitlement, and therefore financial accommodation will be made instantaneously. So the loan arises in the same year as the UPA. On the other hand, if the distribution is proportionate, so if it's for a percentage of the trust income or it's otherwise formulaic, the company will be taken to have knowledge of that entitlement when the calculations are made. Now, the ATO haven't been as prescriptive in saying that this occurs in the year following the UPA, but it's not clear in practice how far the ATO would accept that this could extend. So if you're late in preparing your financials, if it takes you 18 months, 2 years to do, does that mean that the loan arises out of that 18 months or 2 years of the UPA? We're not really sure. What we do know is that the real difference between these two approaches is that deadline for when the UPE either needs to be paid to the company or a loan agreement put in place. With a fixed entitlement, the amount needs to be repaid by the time the company lodges its return for that same year, and minimum yearly repayments immediately kick in. But a proportionate entitlement will at least get you an extra year deferral. As you can imagine, there's a few points here where it's not clear how far the ATO will stretch the boundaries of either of these. For example, is the entitlement to 100% or even 50% of the trust income really a proportionate income, or a proportionate entitlement rather? If there's a single dividend and the amount is known, is that still a sum certain? Ultimately, it means we may have to think a little bit more carefully about how we draft our distributions. Now, again, the determination is still in draft form, so it doesn't apply for entitlements that arise this year. So we're hoping to get some further clarity and ideally some consistency in the final determination when it is released. Which really brings us to how the ATO, the determination interacts with the ATO's other rulings. The ATO released guidance back in 2017 that outlined how it would deal with those PSLA subtrusts or interest-only arrangements that matured that year. PCG 2017-13 generously provided that subtrust that matured that year could be refinanced with a DIV 7A loan on maturity, which essentially gave up to 18 years to repay the original entitlement. So the year deferral, the 10-year interest-only arrangement, and then a further 7 years on DIV 7A terms. The ATO has since then extended that PCG each year. It currently applies for subtrusts that mature on or before the 30th of June 2021, so last financial year. We don't yet know whether the ATO will extend the PCG to sub-trusts that mature this financial year, so before the 30th of June. As I've said, they've done it every year since, but there's no guarantee they'll do it again. Though they have announced the last couple of extensions right at the 11th hour on the 27th of June or even the 30th of June last year. So it's still early days if they do stick to that timetable. What we want to highlight for you is this, that the ATO is withdrawing its previous rulings, TR 2010-3 and PSLA 2010-4, importantly, for trust entitlements that arise on or after the 1st of July this year. This means that it's still open to you to place UPEs arising this year on subtrust. Obviously, these 7 or 10-year arrangements don't have fixed interest rates. We've listed on the slide there the interest rates that apply for this year. The benchmark rate for 7-year terms, which is 4.52%, sorry, or the slightly higher rate for 10-year terms, I think is 6.51%. These will, of course, follow the relevant RBA rates each year, but they're generally relatively generous. But they will change over the lifetime of that interest-only arrangement. Again, it's not clear whether the ATO would extend the PCG to cover subtrusts that might mature in future years for entitlements that arise this year. But what it means is that you need to be prepared to fund the principal at the end of that arrangement. But it still means that there's an opportunity for some tax planning in relation to this year's entitlements before the determination is finalised. We've just got on this slide a timeline of what we're now left with. You'd all hopefully be aware of the changes to Div 7A over the years. It's been amended in piecemeal fashion by Treasury and now combined with the ATO's new rulings has left us with a landscape that's becoming increasingly fragmented. You might have one or more of the following. So pre-1997 loans that are not subject to Div 7A, pre-2009 UPEs, again, not subject to Div 7A. Both of those are subject to Div 7A if that trust makes other loans out or forgives and other sort of discrete circumstances. You might have post-2009 but pre-2022 PSLA subtrusts, so UPEs that arose during that time that weren't converted to loans but were placed on those interest-only arrangements. And from the 1st of July 2022, we're going to have post-22 UPEs that become loans. So while I've said a couple of times now that the UPEs that arise prior to the 1st of July 2022 are unchanged, how these all interact together isn't yet clear. The ATO have made some comments in the determination that aren't particularly clear to us and which we're still seeking further interaction on. But as Alexis will take you through shortly, you might want to consider reviewing your current arrangements to see what you're left with, whether it can be cleaned up, and what opportunities you might have to simplify or to put things on arrangements that sort of defer the funding of that entitlement. And with that, I'm going to hand back to Alexis to wrap up the key takeaways for Division 7A and what you can look for in the future.
Thanks very much, Chanel. Again, it's on the ATO's views on Division 7A. They had changed their view, as Chanel had pointed out, in 2009, and it's only been a short period of time where the ATO again have changed their views on that. It has left us with a circumstance where, as Chanel's last slide ideally pointed out, we could have a whole host of UPEs that have differential treatments depending on the year in which that UPE was created. So for this 30 June, obviously the key takeaways that I'd like to summarise is that there's no change for this 30 June. We should be able to continue to do distributions and place UPEs on sub-trusts to corporate beneficiaries if we need to, and obtain the interest-only option under those guidance materials. There is a one-off opportunity to use those option 1 and option 2 arrangements. So therefore, you do have an option potentially using a 10-year interest-only arrangement, which have at the moment quite low interest rates, which can provide useful funding for business activities if you are using those options. However, as Chanel's pointed out, it's very important to review your existing arrangements. Now we have a lot of arrangements which have different treatment. Keeping track of those arrangements and the treatment of those is quite important to ensure that they are quarantined under old rules. And you may wish to consider whether certain arrangements are repaid earlier rather than later, and how that entity is financed. We do have some of these arrangements that are existing, the transitional, that will need to be refinanced in the future, and the ATO haven't provided any guidance as to whether they will allow those to be refinanced on Div 7A terms. So obviously that would be a major consideration going forward for many groups. The one thing I would like to highlight though is, and from both the presentations, you can see that the ATO are cracking down on trusts, are providing more scrutiny on trusts. And for many simple groups, you may wish to be considering whether operating in a trust structure is appropriate on a go-forward basis. Many of those structures can convert into a corporate vehicle, can roll businesses into a corporate, can operate through a corporate, can use tax consolidation for grouping of losses, etc., and can avoid some of these Division 7A and Section 100A issues because the profits are retained in the company and are only distributed via dividends at a subsequent time, which can be franked dividends. Now, obviously, moving to a corporate structure can result in Corporation Act issues in terms of reporting your financial statements to ASIC, but there's always the review of what your group is, and you would have to consider both the positive and negatives if you were ever to consider restructuring. That is something that we believe that groups would need to put on the agenda again, to consider whether these issues with Division 7A and UPs are manageable, or whether they would be unmanageable, and whether you should be looking at a different structure. Essentially, my last point, I was just going to highlight that UPEs, although we may get these options from the ATO, the one last thing that is not considered really in that TD on Division 7A is that there is an interaction between Division 7A and Section 100A. So although you may get 10-year options and you may get very favourable terms on your UPEs, please consider the interaction with all the Section 100A information that Leo went through, because the ATO could assert effectively that distribution was not intended to provide, be paid off to that beneficiary, and it was there to provide tax benefits and payments to other parties, and therefore could nullify that distribution from a tax perspective as well. That brings us to the end of our session, and I think we're going to open up for some questions that I think have been raised. So I might just check in for those questions that have been.
Yeah, thanks, Alexis. So we've just had a look at some of the questions that are coming through in the chat. Obviously, we probably don't have enough time to get to all of them, but I'll just pick out a couple of the key themes. On the topic of Div 7A, we've got a couple of questions coming through about what people can do in relation to pre-2009 UPEs.
So at the moment on pre-2009 UPs, I think it's too early to go to deal with those, or to start dealing with those pre-2009 UPs. Effectively, if the ATO do take interpretations with those, essentially they will be applying them retrospectively in respect of the distribution that's created in those years. We would be recommending that groups do consider those UPEs and consider the ATO's guidance, and consider whether those arrangements would fall within the ATO's white zone, green zone, blue zone, or if those arrangements would be with respect to a red zone, a risky arrangement. So I think at a first instance that groups should be considering the arrangements that they have and how they would otherwise be risk rated.
And probably a similar question in relation to 100A. So people have pointed out that they've got entitlements that have arisen for previous years. What do they do on a practical note for those entitlements?
Yeah, so this is again another hard question to answer, Chanel. So we do have ATO's guidance that is draft at the moment, and we have a number of court cases going through the courts. And we do believe some of that guidance will change by the end when it is effectively released by the ATO. Though it's probably prudent for groups at the moment to actually consider what distributions that have been made from trusts in their group, and reviewing those distributions going back to 2014, and trying to see whether there are potential risks around those distributions. A lot of cases we would probably see that many distributions won't have very much documentation around the distributions other than distribution minutes. So there may be a chance for the groups to get together and for beneficiaries to acknowledge they have received distributions, and they understand how they have been dealt with, and it has been a part of their wishes to deal with certain things in a certain way, and obtaining appropriate evidence around that, and for those things to be considered. But it is, again, still early in terms of, we think that it will be prudent to understand what the final views are of the ATO, as well as understand what the courts are saying on these provisions.
And I know we're over time by about a minute, but I think we have enough time to squeeze in one more. Obviously, we pointed out the interaction issues with the pre-2009, pre-1997 loans. The government did announce some changes to Div 7A, a couple of budgets, or throughout a few of those budgets, I think 4 of them. What do we know what the status of the Div 7A changes are?
The government on those, the government hasn't come out with any announcement on Div 7A other than a number of budgets ago where they said it won't apply until they've introduced or had royal assent on the provisions. That's the only official comment we've had from the government. We have had interactions with Treasury where they have ranked it as a low priority, and they believe that a lot of the issues are dealt with via the ATO releasing these guidance documents. Funny enough. So there's probably a low chance that those amendments are going to happen anytime soon. Therefore, I mean, that works both ways because Division 7A, there were some amendments that were going to be taxpayer favourable and some amendments that would go against taxpayers. Just as an example, I think that 25-year loans were on the list of amendments where they were going to remove 25-year loans from Division 7A when they're secured over real property. That option may still be available going forward, and with the low interest rates provides a pretty good option for Division 7A funding on a go-forward basis. So absolutely, it's we think some of these things could still be on the table, but yeah, there's no real update from the government on this last question.
Thanks. And I know I said the last one was the last one, but we've just seen a really interesting one that's come through. Is there any chance of an amnesty period considered for cleaning up, say, the last 3 years for family trust arrangements that might be in the red zone?
Yeah, I think this is a fantastic question. I'm glad that one was raised. We have, through consultation processes, we have highlighted that the key issue is transitional. The ATO haven't provided appropriate guidance on this provision, and the ATO would have looked a lot better than what they do at the moment if they had have come out and made this a prospective type of provision and provided some kind of amnesty for cleaning things up. I think that's where a lot of the backlash is, because the ATO have done reviews historically, have signed these things off, and have contributed to the problem as a part of that. So we are definitely pushing for better transitional relief around Section 100A. We've also noted to the ATO that this should be an area that the Inspector General should be reviewing in terms of the ATO's past practice around this area and the consistency of application in audit reviews as opposed to what they're saying in their guidance material. So we do think there's a strong chance for some movement around transitional. The unfortunate part is, though, on this is that the ATO have court cases before the courts, and the problem that may occur is that the courts may decide in favour of the ATO, and then we are stuck with a court decision where the ATO are very reluctant to provide amnesties when we get to those situations. So they may have their hands tied, and we may need to have government make amendments. My last point is that both sides of government have come out and said that if the ATO are looking to apply these provisions in a more broader fashion than was originally intended, that they would look to review the provisions with a potential change of law. Now, those are just words that they've come out with over the last week. There's no guarantee that they will do that, but it's positive that they've both come out on the record stating that they would look at this if the ATO does push this further than what it should otherwise be. Okay, well, great. Thank you, everyone. Thanks for attending the presentation. I hope you got a good outline of how these provisions will work. Again, if you have any questions, please feel free to contact your pitch partners contact with any questions, and we'll obviously update you as we go on with any amendments that happen between now and 30 June. So thank you again for attending our session.